Most people have no idea what goes on in family court. They can be very afraid to go there, and for good reason. As I covered in episode 60, family court is definitely not for everyone. Many people may be better off avoiding it, but for my clients who are in family court, they find it a lot easier if they know what to expect. In this episode of the Ontario Family Law Podcast, I will go over what the first time in family court looks like and what goes on. That appearance, which is called a case conference, is very different from what many people expect. I'm Judge Schuman, a certified specialist in family law in Ontario with extensive experience assisting clients with high or complex incomes. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law. The 5th edition is now on sale with many additions and updates to the previous editions, which many people found invaluable. It is available on the iBookstore, Amazon, and in fine bookstores. My book goes over the complete family court process step by step with explanations of what happens at each step. So get a copy of my book if you have any family law issues. And like and subscribe to this podcast to get more family law information headed your way. In most circumstances, the first time the parties to a family court matter go to court, they are not seeing a judge. The first time they go, either in person or over Zoom, is for a mandatory information program, which is essentially a class for separated spouses and parents that covers 3 main topics. 1. The options available for resolving differences, including alternatives to going to court. 2. The impact of the separation of parents has on children. And 3. The resources available to deal with problems arising from the separation. Sometimes the parties have to go to a first appearance, where a clerk makes sure the parties have served and filed all the right documents and filled them out correctly. That date is with a court clerk, not a judge, and often in a small office or a small courtroom designed for this purpose. If everything is filed properly, the only thing that should happen is that the parties will get their first real court date scheduled at a later date. In family law proceedings in Ontario, the first court appearance before a judge is supposed to be a case conference, although in some courts, and for some types of cases, it isn't a judge but a dispute resolution officer who is a senior family lawyer that conducts the appearance. To make case conferences a productive discussion of the issues, the family law rules require the parties to be present in court and prepared for all conferences, including having the exchange disclosure. The case conference is a less formal meeting between the parties, their lawyers, and the judge. It is not supposed to be adversarial. A week beforehand, the parties file case conference briefs, not affidavits or other evidence. The briefs should not set out why the other side is wrong, but the briefs should set out what the parties disagree on and why they have not been able to settle outside of court. In episode 79, I went over how parents have a legal obligation to try to avoid family court. The brief should also explain what is necessary to either move the case forward through the court system or get the parties to a settlement. This is to help the judge figure out what is the best way for the family to get through the issues and move on. At a case conference, the judge does not make a decision on substantive issues, the important issues between the parties. Instead, the judge makes decisions about procedural matters and disclosure and other small issues to help the parties move forward. Sometimes the judge will make recommendations about how to resolve the big issues on a temporary basis, but those recommendations are not binding. Since the judge's powers at case conferences are limited to procedural and disclosure issues, except for the ability to make orders when the parties agree, they can delegate case conferences to dispute resolution officers, and that can help get the parties to a conference before they could if a judge had to do it. In a few court locations, when both parties have lawyers, the judge holds the case conference in a meeting room rather than in open court. This is because, unlike other court appearances, conferences are not supposed to be adversarial. The idea behind case conferences is to allow the parties to have an open exchange of their positions on the issues with the judge present who can give non-binding opinions about each party's position. That can be easier to do in a smaller room. But increasingly, judges have conferences in a courtroom. The only indication that the appearance is less adversarial is that in Superior Court, the lawyers do not wear their robes. In some courts, the judges do not either. That is to give the impression that the case conference is more of a 3-way conversation than a formal court appearance. but it is almost always still a very serious appearance. When the case conference is in person in a regular courtroom, the parties sit at the counsel tables closest to the judge's dais. The applicant is supposed to sit on the right side going in to the judge's left, and the respondent is supposed to sit on the left side going in to the judge's right. In front of the judge, there will be room for a court clerk and a court reporter. In some cases, there may also be a court security guard or a police officer on one side of the judge's dais. Then the judge sits up on the dais. The judge can feel a long way away, and the dais is almost always elevated, so the judge sits looking down on everyone. That setup often requires more formal conversations, and where the parties have lawyers, it's usually the lawyers who speak to the judges based on their client's instructions. Although, in case conferences, unlike motions in trial, sometimes the judge will ask the parties simple questions directly. In the more adversarial appearances, that only happens when the judge is telling off a party. Some courthouses have case conference rooms where everyone sits around a table, or the judge just sits behind a desk with the court clerk and reporter off to the side. That is a more natural way to have a conversation, and so in those cases the conversation can be less formal, although the judge is still very much in charge and everyone has to treat the judge with respect and call the judge Your Honor. Usually appointments with dispute resolution officers are in that kind of room. You call a dispute resolution officer by their last name, plus Mr. or Mrs. as the case may be. Things can often seem less formal when case conferences are on Zoom, although often the judge's background shows the judge to be in a courtroom and the camera is positioned so the judge is still looking down on everyone. Unless the parties are in the office with their lawyers, it is impossible for them to talk to their lawyers during a video conference. They may be able to email their lawyer. In some instances, the video conference allows for a less formal atmosphere, so the conversation can be less formal. But remember, the judge is still in charge and parties should not speak unless the judge asks them to. Before moving on to what that discussion is about, if you are finding this episode helpful, please hit like and subscribe, and also hit the notification bell so you can be notified of additional episodes. Also, remember that the new expanded edition of my book covers all family law issues in greater detail and points out where the law comes from to allow people to find it. The focus of the case conference is usually on setting up the procedures necessary for the parties to move towards a resolution. That usually involves setting timetables, addressing any outstanding disclosure issues, and making other procedural orders to allow the case to proceed to trial in an orderly fashion. A case conference judge can make any procedural order that is necessary to move the case forward. However, they cannot make any substantive orders, such as orders regarding support, custody, access, or property issues, unless the parties agree on the order. That is because judges need evidence to decide issues, and except in exceptional circumstances, there are no affidavits or live witnesses at case conferences. Focusing on evidence usually causes parties to focus on their differences rather than the way to resolve them. Case conferences are all about trying to resolve things, even if they are small issues. At case conferences, judges can still be quite blunt about what the parties should agree on. The judge will often say what he or she would decide if that judge were deciding on the motion, and will warn the parties about the costs and other consequences if they go to a motion and lose. The parties are still free to disregard and asked to argue the issues at a motion instead. In the Superior Court of Justice, a different judge hears the motion. That motion's judge may see things differently, or may see things exactly the same way as a case conference judge did. In the Interior Court of Justice, the same judge will hear the motion as presided over the case conference, which means the result will probably be what the judge predicted at the case conference, unless the evidence is very different from what the judge anticipated. There are some important things to remember at a case conference. 1. Get financial disclosure done first. The family law rules and judges put a big emphasis on getting disclosure done right at the beginning of family court proceedings. Without disclosure, the case conference will be less productive and the judge will be angry, which can work out badly for one party. 2. Only speak when the judge speaks to you. A conference may be less formal, but is still a judge there and the judge is in control. 3. Don't argue with the judge. The judge is still a judge and still in control. Everyone has to be respectful. If you suggest that the judge is wrong, that will make the judge angry, and that can lead to bad things. Sometimes it is possible to carefully point out that the judge did not know or missed something, but that is really important and you have to be very careful. 4. Case conferences are not where you prove your case. They are not about showing you are right. The best you can hope for is to show a judge that you are the more reasonable, likable party, and that can pay off later. 5. Dress nice. This is part of being respectful. If you dress like you are on the golf course, or on the beach, or working on your car, or at a party, the judge will not be impressed. You still want to make a good impression on the judge, so the judge has sympathy for you. This is regardless of whether you are in person or on a video conference. 6. If you are on a video conference, make sure your lighting is good. You don't want to look like a vampire, or a ghoul, or a psycho. Get help at this at your local camera shop if necessary. It's important to make a good impression. 7. Don't speak out of turn, and don't make it look like you are not listening to your lawyer. If a judge thinks the party is out of control, the judge will make orders to control that party, and that won't be good. Although judges cannot make substantive decisions at case conferences, judges can make procedural orders that can really affect how a case unfolds, and that can make it much more difficult for one party to advance his or her case successfully. So it is still really important to keep the judge on side. It is also important to make sure that the judge knows that you are reasonable. How do you know if what you are doing is reasonable before you see a judge? Like and subscribe to this podcast. Get a copy of my book and talk to a lawyer about your situation to figure out the best position to take, the best path to follow, and maybe to help you decide if you should be in family court at all. If you are finding family law or children's law confusing or difficult, or you just need to understand it better, or you need to know how best to make parenting work after separation, or if you need to understand how finances work during a marriage or a common law relationship and after separation or divorce, get the latest edition of my book, Guide to the Basics of Ontario Family Law. The latest edition is currently on sale at a reduced price because I want to get it quickly onto the bestseller list, like all the earlier editions. You can access it immediately on the iBook store, on Amazon for the Kindle version. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with me or one of my colleagues. You can also contact us to make an appointment to speak to us using the contact information below and in the description. It is always best to get a lawyer who can give you expert advice that's specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter or X and Mastodon at SchumanFamLaw, and finding me on LinkedIn. I'm also on Threads. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get all the episodes at www.schumanlaw.ca, just for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.